Welcome to the House Judiciary Committee this Thursday morning, April 10th, and we're going back to S87, an act relating to extradition procedures. We have amended language in draft number 1.1, which is an instance of amendment. Michelle is tied up on something else, so Todd is going to walk us through this amended language.
Good morning. For the record, Todd Daly is Assistant Attorney General, and I feel honored to pinch hit for Michelle Childs, but of course, she is the right expert in this space. So just to walk the committee through draft 1.1, when we last spoke about this bill, there were concerns raised by the Defender General about potential duration that individuals may be held in custody while the process of a pre-signed waiver played out. There were questions about how long Vermont could be on the hook waiting for other jurisdictions to act and actually take someone. The demanding state could come and retrieve someone. And so in response to that, working together, the state's attorneys, us and DOC have put together some language that then Michelle made actually work. So I'll walk you through that and should also flag that DOC is here today and can also speak to any specific questions that folks have on this. The person who actually runs this, Morgan Rogers, will really be able to answer a lot of questions. Great. So looking at section D1, this is the first part that provides DOC with the express authority to hold someone while the documentation is both requested and assessed. So you'll see in D1, first of all, the arresting officer would provide paperwork, essentially, that attests to the fact that A, the person has broken the terms of probation, parole, or otherwise in another state, that state has an extraditable arrest warrant. And I just want to pause there for a minute, right? There are plenty of people who may have broken the terms of probation and parole, be picked up in Vermont, flagged in the demanding state, and they say, this isn't a crime we're going to extradite and prosecute them for, and Vermont would then not move forward on it. There may be other reasons to move a criminal process forward with an individual, but it would not be on the basis of a fugitive warrant. And then C would be the flag that they had, again, signed one of these pre-signed waivers. I'll let Morgan talk more about this, but one interesting point I just want to flag, and she is the expert here, is that in her experience, now I am speaking for Morgan, but she'll clarify this. I found this really important because I hadn't heard it before. Most of these pre-signed waivers are post-adjudication. So these are not instances of somebody being arrested, charged, and released on their own recognizance and then getting picked up in Vermont, a fugitive warrant. Most of them are arrested, charged, convicted or pled, released for probation or parole, and then and so I know there were concerns around due process in the other state and whether it was just a charge or an actual conviction. Her experience is mostly convictions, which I think is important for some of those concerns. So moving on to D3 at the bottom of the page, that then is the express authority for DOC to hold the person under those conditions.
So you're talking probation status or furlough violation, something like that?
For the most part. I mean, to be clear, it could be anything,
right,
but those are the ones that, and again, I'd let Morgan speak to that, but I just want to flag that because I know that was a concern that was raised before and certainly one we had talked about. So then E is the time limit. And again, Morgan can speak to sort of how we came to 14 days. And it's business days, and it's not business days, it's calendar days, so that DOC is operating 24/7. It seemed like we didn't want to juggle what a business day is. It's just 2 weeks.
A day is a day.
Yes.
It's a day. This committee loves
favorite law that I've done in the last 11 years. So
yeah, and
glad that you're sticking with the day is a day.
only I'd known to tee that up better.
Next time.
Yeah, next time. So that's 10:30. Sorry. So that then what it says is after 14 days, if that person isn't picked up, they're released, or the arresting officer can go through and file the paperwork to begin the full extradition process and not go through with the pre-signed waiver.
That's a question right there. So if you go to remind me, when they go to the full extradition process, the individuals being held at that time, that's where that 90 days plus additional 30. So they will be held once that process starts.
Yes, but we should be clear on what the term held means in that circumstance. Again, they're only actually in carceral custody if the underlying crime in the demanding state has a penalty up to life.
Oh, okay. Right.
This is Senator Ghostline had the Senator Representative Ghostline.
Nobody.
I was out of promotion.
Yeah. You have to talk to Representative Oliver. Had raised the question about, how long are these folks around? Are they out in the community? How do we find them again? And I think it is important to recognize if it isn't that kind of penalty from the demanding state, then they are released on their own recognizance here in Vermont until that 90-day or 120-day process plays out.
Or they can be held on bail.
They can be held on bail. Yes.
And we're telling them in the other part of the bill, telling the court to make sure that it considers the fact that they were already a fugitive once and their risk of flight assessment.
Absolutely.
Okay. Yeah, Barbara.
So I have one question on something you said earlier. When you said that often states don't want to necessarily extradite for that time, when and how is that found out?
I will leave that to Morgan. It's a great question for her, but essentially, my understanding is it's flagged in the system, the NCIC. Then there's a phone call made from, and Representative Oliver could probably speak to this too. There's a phone call made. You actually call the demanding jurisdiction, and they may say, "Oh, you know what? The prosecutor decided we're not going to prosecute this case," and then they withdraw the warrant that sits on NCIC. So that's going to be a prosecutor's determination in the demanding state.
Right away.
Yeah. Well, once we request the paperwork from them, that's going to.
Ian.
So just while we're still on this section, just given that explanation about how someone is held either on bail or without bail, depending on what the underlying charge is, if they're going through the extradition process, the formal one, it really means that we're creating this other situation where someone's going to be in jail, they haven't been before a judge, and they're waiting for extradition based on the waiver. Based on that, I would want this to be the shortest amount of time possible that we're saying that that's okay. And so if you can just sort of if it's you, should I ask, or I ask somebody else, what the rationale and justification was 14 days?
I can, again, Morgan, I think is the real expert here. My understanding is, I feel like I'm just speaking for Morgan because she's,
so we can save that question.
why don't you say that?
I'll say that. Yeah. All right.
I support the 14 days. I'll say that. And Morgan will tell you why I do.
Immediately.
It's immediate.
Yeah, that's not.
So then getting to the last piece, F, this is just if DOC finds mistakes in the paperwork at any point in this process, essentially what this language says is they'll tell the arresting officer, we need a different reason to hold this person, and you'll either file a fugitive from justice complaint and get them in front of a judge immediately. And if they're not in front of a judge immediately, they're released.
Okay.
So does that mistake happen frequently and that's why it's in the bill?
I would let Morgan speak to the frequency. I don't believe it is particularly frequent, but DOC does look to confirm those. She may, in fact, have a couple examples that could help illustrate that.
Thank you.
Yeah. Is there a reason it needs to be DOC?
Who finds the error? I suppose law enforcement could be included there as well. I think the thought process is the way that this procedure rolls out. At this point, that individual is being held in custody, and DOC is confirming, as they do in a couple other areas, interstate detainers and interstate supervision. They confirm all the paperwork going back and forth before they release somebody or transport them to, release them to transport to a demanding jurisdiction. So that's, I think practically it's DOC, but I take the point. It doesn't have to be limited to DOC if law enforcement also found an error. I just don't know, and I would look to Representative Oliver possibly on this. I don't know how often the arresting officer would be involved in the process at that point in time. So the question, this is section F. If DOC discovers an error in the pre-signed waiver, they then have to act. And my understanding of Rep. Goodno's question is like, would a law enforcement officer also potentially run
That
into an
or
error?
state's attorney.
Or anybody else. I guess just the way it reads right now is it's only DOC. If DOC discovers an error, then they're going to have to take action on it.
I think it would make sense to have more. I would simply suggest if DOC wasn't the one who found the error, DOC is still the one who has to act because they're holding the individual. So somehow that has to get communicated to them. I suppose one thought here is anybody could communicate that to DOC, right?
Yeah.
So the prosecutor could say, hey, wait a minute, there's something wrong with this, or there's another flaw.
If DOC is made aware of an error,
Discovers or is made aware of an error.
I think, if they talk to the law enforcement officer, they would probably contact the state's attorney and they'd probably say file the extradition paperwork, but I guess it would depend on what the error is.
Yeah. And maybe that's a good question for Morgan to sort of like what those errors are. Or Kim might have an answer to that.
Other questions? I have a couple questions. For folks, this is something that circulated among various witnesses, and I understand that the Defender General's office is not in favor of this language. We'll have them in. They can't come in today. We'll have them in next week, and we can have Todd and Kim and others in as well if they want to respond. But it's their position that there should be some court process by which the validity of the advanced waiver of extradition is examined. And I guess my question for you is, it seems like an expedited process for the court could be put in here, and what's the arguments against having that?
I guess they are twofold. In the first place, the goal here was really to streamline this process where, again, an individual has pre-signed a waiver to say, if I violate my conditions of probation, parole, and go to another state without authorization, I agree that you can extradite me without process. So they've already gone through some waiver process. And the goal really is, as we talked through the first time, to avoid the long process of the governor's warrant for these pre-signed waivers. So adding some piece of judicial process, I understand it. And from our point of view, this is much more aligned with the Interstate Compact for Adult Offender Supervision, or the Interstate Agreement on Detainers. Both of those are current statutes.
Could you give us the citation?
28 VSA Chapter 22 is the Compact on Supervision.
Right.
Happy to loan somebody this green book. And Chapter 25 of Title 28 is the Agreement on Detainers. Those are two administrative processes wherein DOC is in communication with a demanding jurisdiction, receives, assesses paperwork, and then processes an individual through a corrective process, not a judicial process, moves that person back. So for example, if I were on, I don't believe I am, if I were on probation in Massachusetts and that supervision in Massachusetts was transferred to Vermont so that I could live my life in a different way or to otherwise accommodate a need, Vermont would take on that supervision under the compact. If I violated the terms of that Massachusetts probation in Vermont under Vermont supervision, as I understand it, and Morgan can walk you through this in great detail, DOC would has the authority to simply hold me and transfer me back to Massachusetts. There is no judicial process in that because that is an administrative process. We see these pre-signed waivers as very akin to that. DOC is not in the habit of moving people without proper authorization, holding people without proper authorization. And so from our view, that is the administrative, it fits in that administrative bucket and it has the right checks and balances there. The other piece is simply, while it could be an expedited process in front of a judge, that feels like another step and another burden on the judiciary and is not moving in the direction we'd like to see this piece of extradition move. And again, that's why we tried to put in some off ramps to the full extradition process if there were flaws in the system or somebody was being held. If the demanding state had.
So before I go to Tom, my understanding is there's only a couple of these a month, so it wouldn't be that much of a burden on the court, would it? Or did I not hear testimony last week properly
That may be the case. Morgan can give you a sense of the numbers.
Tom?
In the case that it's somebody that's not in DOC custody in another state, I feel as though I think it would just mirror the same situation that happened here if they signed a waiver to extradite themselves back.
Yeah.
The clock would start and the procedure would start and operate just like that.
I agree.
Okay.
Other questions for Tom? Not seeing any. Let's go to the real expert.
Happy to be
Speechless. I know, but he kept on saying, well, I'm talking for Morgan, talking for Morgan.
happy to be of service.
So, thank you, Tom. That was very helpful that you did the walkthrough for us. I appreciate it.
Yeah, right.
I do. Sorry about that. Morgan, thank you so much for being here. And
You're welcome.
Morgan, no.
I
So
have, my audio is a little off, so some of you are delayed, just so you're aware.
okay, all right, I appreciate that. We're hearing you fine though. So if you could proceed and identify yourself for the record, and if you have a particular statement or if you want to handle some of the questions that you've probably already heard, we'd appreciate it.
Absolutely. My name is Morgan Rogers, and I am the Department of Corrections Extradition Manager. I've been with the department for just shy of 15 years, and I will have been in this role for 14 come November of this year. So in my role, I take on incoming and outgoing detainer cases for people who are pretrial and post-adjudication. And as Todd referenced, that's the return of people under the Interstate Compact for Adult Offender Supervision who are returning to their state after violating in this state. And on the other side of that, I am the state's Interstate Agreement on Detainers Administrator, which assists in allowing individuals who have been sentenced to a term of incarceration in a penal institution and haven't had an untried warrant lodged against them as a detainer to invoke their speedy trials under the IADA, which is a federal act. And that's the transfer of that individual from one state to another, again, dealing with warrants. And that one does have court processes once that individual is in the other state. I did try and keep track of all the questions. And I think I covered a little bit there. So please remind me if I go off course. To the supervision piece and due process, again, the Department of Corrections currently acts in roles where we are evaluating the documentation from other states and using that information to lawfully transfer custody back and forth. Obviously, those are post-adjudicated cases where the person is under supervision if we're talking about violations of parole or probation. And then there is the other side of what I briefly discussed with the Interstate Agreement on Detainers. And as I have explained to Todd and Sophie and the others I've discussed, I could talk about extradition all day. It is not a cookie cutter process. Every case is evaluated independently because every case has different characteristics and scenarios attached to who the person is and how they became a fugitive from justice. So I think we had a question on the 14 calendar days, how we came to that number, and yes, the 14 calendar days. And initially, I believe it was 10 business days, and to calculate out 10 business days upon detention in a correctional facility is more challenging than counting out just 14 business days once we assume custody from law enforcement. I think I would like to emphasize too, the fugitive from justice process is a civil process. It is not a criminal process. We are not arresting anyone in this state as a criminal fugitive from justice. These proceedings are based on pretrial conditions of someone who's been charged with another offense or post-adjudicated supervision violation in which a warrant has issued. And the demanding state has requested the warrant, and we are the asylum state who is apprehending the individual. I know there was initial concerns with identification, and the short answer is law enforcement isn't going to arrest somebody that they cannot identify. It just doesn't really happen. I think in the 14 years I've been doing this, there's been one case where we have had to fully rely on fingerprints to confirm a person's legal name. But we knew they were who they were. It just so happened they were wanted in 5 different states under 5 different names, but in every one of those states, there were fingerprints attached to those offenses, so we were able to determine who they were. And then it just became a choice of who got them first. The 14 days, again, back to that, and the recognizing holding somebody for the shortest time possible. We have inconsistencies across our state for outgoing fugitives right now. Some judges will allow 7 days, some will allow 10, some will allow 30, some don't allow any. We've had situations where New Hampshire has wanted an individual, and just because of the location, the assumption is they can immediately be there. And to that end, with the burden on the judicial system, the bed space in correctional facilities in Vermont, and we are seeing nationwide a decrease in active law enforcement. So just because somebody's right next door doesn't necessarily mean they can come over immediately to retrieve somebody. So that is how we landed on the 14 days. In many rural counties, and they allow for 30 days, no questions asked. But realistically, we're talking about a uniform act that there's no uniformity to whatsoever. And each state is doing the best they can, and within those states, each county. I will say that Vermont is super unique. Typically, these cases, a fugitive from justice case where a person is apprehended off the street, they are handled by local PDs and county sheriff's departments. We do not have local lockups. So that is why a lot of this language references DOC and their authority, because in other counties and other states, the law enforcement agency, an agent who is arresting the person, is part of the detaining facility. So the detention center is within the county jail system. We don't have that opportunity here. And for years, in fact, a little short blurb, I now Judge Treadwell, and now retired Major Trudeau, when I started in this position, we discussed greatly how amazing it would be if the state would adopt the acceptance of pre-signed waivers to help reduce the burden on law enforcement and the judicial system for those cases that we can clearly identify that the person has executed this waiver in conjunction. And as I said before, most often in cases where it's a post-adjudicated case where they fled from supervision or violated their terms of supervision, and a supervising agency, Department of Corrections, has issued a warrant for their arrest. To the concern with the Defender General's office where there's no judicial process accepting these pre-signed waivers, I would also highlight the interstate agreement on detainers, which has an executed waiver when we are transferring custody of people. The Interstate Compact for Adult Offender Supervision, in which the government has determined the Uniform Extradition Act does not apply to that because they've waived their right to fight extradition upon request for transfer. And then I would also highlight that the state itself has granted both the parole board, who is a non-judicial branch, and the Commissioner of Corrections to issue warrants for furloughees and parolees who are under supervision in the state of Vermont. And those agreements, both the parole agreement and the furlough agreements, have pre-signed waivers attached to them. So we're in a unique position where our supervised individuals execute a pre-signed waiver and our state currently does not even accept them. I think I got all the questions.
All right, so other questions? Tom?
Hi, Morgan. First time I've seen you and talked to you at the same time.
This is true.
Um, I like what this is, where this is going. The one thing I really wish it could deal with is to pretty much do away with the whole arrest process of someone wanted in another state because they have a warrant in another state, and just the fact that there's a state line really puts another burden on law enforcement, as you know. How do you feel about that?
Do you mean like the arrest process in itself, as in a law enforcement agent in the state of Vermont being able to transport a wanted individual across state lines, or
No,
the
no,
actual arrest and detention of them with an affidavit that's drafted by law enforcement?
right. Suppose I arrest somebody from, say, the state of Florida. It's pre-adjudication. State of Florida is demanding their return for some crime, hoping, that they get arrested. And we return them based upon that warrant, but we would obviously have to put them in jail on that warrant to make arrangements to get them back to where they need to go. But in Vermont, to do that, we have to do an affidavit under 4954 to accomplish that and go before a judge here to set bail again, etc. In Vermont. What are your thoughts about being able to bypass the whole arrest process? It's like you're doing it twice. Somebody else already did it. It was just in another state.
So, from my experience, and I like to say I am not an attorney, but from my experience and in the legal terms, I would not support doing away with the arrest procedures for a pretrial case. That is an area in which probable cause may have been found in the initial filing of that case, but if the person hasn't been convicted, that charge has the ability to be amended throughout the trial process. For the cases that are typical, I would say pre-arraignment, and a warrant has issued simply based on an officer's charge and complaint against a person, and there's been no judicial process yet, I would be hesitant to not do away with the arrest procedure in those cases. And that's why I did try to emphasize too that the majority of these cases we see with these pre-signed waivers are post-adjudicated. There are some states who are moving towards pre-trial bail conditions that do include a pre-signed waiver of extradition. In fact, I spoke to the Chittenden County State's Attorney about that because they had a case with Florida where they were very frustrated in that the defendant refused to waive extradition. And I said, well, I mean, make it part of your pretrial release conditions if you want a waiver associated with it. So I know New Hampshire has issued a few, and Sophie and I have discussed that, and a few of the governor's warrants that have come in recently have included pretrial waivers of extradition associated with being released on your own recognizance or on bond. But I don't think that is what this bill is intended to do. And
No.
again, I would be hesitant if it's a pre-trial case to
Right.
do away with arrest procedures.
I'm merely pointing out that it has had some judicial screening because a warrant was produced by the demanding state. There's been a finding of probable cause. They just have not been convicted. And the same would go for somebody who's potentially facing other charges that may be corrections related, that they still would have the right to a hearing.
So I think what's unique in Vermont is when our officers draft a request or we have a crime that's been committed, our court system issues the warrant. There's already been probable cause found. Law enforcement has provided that documentation to the state's attorney's office, and it goes to our criminal court, our superior court division. That doesn't happen in every other state.
Nope.
Other states' judicial process goes as low as a town court in some counties, and then goes to a county court, and then can go to a district court. And it jeopardizes the process of the actual fugitive case if we eliminate recognizing that not not all warrants are issued by a superior court judge who's found probable cause based on an officer's affidavit. I think the only way around that would be an indictment, where a grand jury has indicted somebody. And we've determined that, I should say, law has determined that an indictment does not require an affidavit because a grand jury has found probable cause. So it would be great, but
I would definitely agree that because it's not standardized across 50 states, that's kind of unreliable.
yes.
I just want to clarify, then go to Ian. So you mentioned pre-arraignment, but I assume that there wouldn't be a signed waiver if it's pre-arraignment. That would be
Correct.
okay. All right, just want to make sure
Yes.
that. So all right.
Yes.
So pre-trial, so there's a pre-trial situation where somebody's been released on conditions. One of the conditions is that they've signed this waiver of extradition, and then there's post-adjudication. Understand that. Do you know, or does the law enforcement know when they get the warrant, what status it is, if it's pre-trial or post-adjudication?
Through the NCIC system, it should be identified clearly for law enforcement to be able to see that, either in the conversation between the two dispatching agencies, state to state, or with the paperwork that is received. It's quite clear when you see a warrant and the NCIC entry that accompanies an individual who is wanted. That's how we're able to see when somebody's wanted in another jurisdiction. They identify both the severity of the offense in which the warrant was issued for, and if entered correctly, will identify the most severe crime associated with the warrant if there is more than one. So they should be able to see that.
And I mean, is it, and maybe you're not the right person to answer this question, but the level of due process that a person has received for the pre-trial situation where they've signed the conditions of, as part of the conditions of release, or the post-adjudication, it seems that if we're relying on the due process that was given in the other state, it's a lesser level of due process for the situation where it's only at pre-trial.
I'm not going to speak to the legalese of that, but I would agree that it's less, yes. And I think the key is, again, really emphasizing that we are going to see these pre-signed waiver cases in situations where they are violations of supervision. That's going to be the majority of these cases. And I don't think anyone wants to do away with the due process rights of an individual who has not been convicted and who potentially, as you said, is released on pretrial conditions. The documentation that we receive is very clear. It comes from the courts and it comes from the state's attorney's offices, and it typically outlines the steps and the process of which has happened in the pretrial case already. Again, I would just emphasize the ones that we see most frequently are associated with violations of supervision and absconding from that supervision.
All right, and I just want to make clear, the ones that you're seeing are the ones that have gone through the whole process.
Correct.
All right, just wanted to confirm that. Ian and then Tom.
I think piggybacking off of Martin's question, I'm hearing there's not a lot of uniformity. It's very scenario specific for each of these, which to me sort of starts to make me want to have some sort of judicial process in here to check and ensure that people's rights are being protected. That said, I'm kind of curious on the ground of this. Could we bifurcate this and say that there's a system for pre-trial waivers and for post-adjudication waivers where there was sort of a certain set of things that had to be done if they were picked up on a pretrial waiver versus the post-adjudication? Like, does the system exist that could make that possible? Or when we're talking about these waivers and how to implement them, we've got to basically make one uniform decision?
I don't think that is unreasonable by any means at all. Right now, the United States is split about 50-50 with who accepts pre-signed waivers and who does not. the states that closely mirror ours, which are Hawaii, Rhode Island, Delaware, Connecticut, and I'm forgetting one. So I apologize. Those are all uniform correction system. Again, we're unique because you're sending these people to the corrections department, not county jails. The overall position of the National Association of Extradition Officials, which is a nonprofit that oversees annual trainings for extradition officers across the United States. They do support the acceptance of pre-signed waivers and have since 1986. All that being said, none of the statutes differentiate between pretrial, post-conviction, and it's kind of a very, what we're trying to do here is really kind of allow for the language to be present in statutes so we can reduce some of the burden of work, but recognizing that not every statute is going to be so specific to what is and what is not accepted. Again, I would not oppose treating them differently, and I think that would just be a training. It would be something we'd have to train and make sure that law enforcement is aware of. And even so, and I've said this to Todd, even if the decision is to make this a judicial process and have a judge oversee it, we're moving in the right step forward by at least addressing that these types of cases exist. And we should be looking into it. So I absolutely appreciate being here to testify to that. And I think either way, it's beneficial to the state as a whole.
Oh, yeah, just, and then my only follow-up was, is it possible for us to actually get the numbers on how many pre-trial versus post-adjudication extraditions are done in Vermont in a year?
I did ask if I could pull the data for those who have been housed as a fugitive from justice for the past year. That is information that our data team would be able to pull. It would probably be easier to pull it based on facility versus the department as a whole, but I can definitely look into that. It would take an independent review of each one of those cases by either myself or the state's attorney's office to determine which one is pretrial and which one is
I don't
post-supervision.
know.
Not necessary though, then. No,
Just if it was easy to get, it would be an interesting data
The
point.
numbers would be easy, yes, but what type of warrant they were would be more challenging.
Ian's trying to jeopardize what I was thinking.
Yeah.
In the scenario that I gave previously, which was pre-arraignment, it seems like post-arraignment is where this should all start and just run the same policy through. Most of the time, unless it's a corrections waiver from some sort of court hearing, it's gonna, your conditions of release are gonna start right at arraignment. Correct?
Yeah.
And that's where we're gonna develop or have to develop what we're gonna do. And I think it seems to make sense that if it was standardized as one shot, it's gonna be post arraignment all the way up through post adjudication, correct? I mean,
It sounds like we don't have to.
post adjudication, your only time you're gonna come up with any conditions is if they're released on bail before sentencing.
Or probation.
Or probation, correct. But it's obvious if they've signed a waiver, they know they could be incarcerated if they leave. So,
So just this may not, I mean, the amount of due process that was obtained in the arraignment and pretrial versus post-trial, that might not be where the Defender General's concern is, because they're talking about the validity, the court process by which the validity of the advance waiver of extradition is examined. I suppose part of that look could be how much due process they had leading to them signing that waiver, but it could be other things as well, as far as the validity. But, we'll hear from the Defender General on that particular issue. Other questions for Morgan? Because I kind of want to just make sure I understand this better. So if you could, Tom, no, go ahead, Tom.
no, I'm good. I came up with the answer.
Okay, so Could you just, again, I apologize for this, but if you could walk me through and particularly with respect to these other processes that we're talking about being equivalent and should give us comfort as far as what we're looking at in S87, this amendment. But as far as the detainer issue and what was the other? The other issue is adults under supervision. Can you just kind of walk through how those two are equivalent to what we're trying to establish here for the waiver of extradition?
Sure. I think the equivalence that I am trying to share with the committee is that the Department of Corrections is already tasked in a capacity to review legal documents and how they're applicable to individuals who are in our custody. So and mind you, both are part of extradition, but they are on two very different sides of extradition. So for the Interstate Agreement on Detainers Act, that is for specific to an individual who's been sentenced to a term of incarceration in a penal institution in which a demanding state has an active, untried warrant for criminal offenses that they have lodged as a detainer. Lodging as a detainer, the term is very loosely used, and it is just more often defined as a written confirmation of the willingness to extradite the individual to prosecute on the untried charges. It is the Department of Corrections' responsibility to notify anyone who's in our custody who is serving a term of incarceration, so they're sentenced on Vermont charges, that a detainer has been lodged against them by another jurisdiction, and they have due process rights, speedy trial rights to invoke resolution under the Interstate Agreement on Detainers for disposition of all pending charges in that other state.
So let me ask you a question. When you say under custody, so the individual might not be incarcerated, they may be on probation.
They're serving a term of incarceration in a penal institution. They are in custody.
So they're already in custody. So holding them for the detainer doesn't seem to be the same kind of situation as what we're dealing with in this bill.
It is and it is not. The very end piece to this, and again, this is me trying to share the types of processes that the department is involved in that is relevant to reviewing the validity of legal documentation. So we're receiving these, and we are responsible for notifying and providing them this information, determining that this documentation is correct, and sending them to the other state. That's the response of the individual can either be, yes, I want to invoke my right to a speedy trial, or it can be no. So if they say yes, they go back to the other state. Part of this process is they're waiving their right to extradition upon return to Vermont if the other state in which they were sent to has convicted them for a term of imprisonment that exceeds their term of imprisonment here. So I'm serving 2 years here. I go to New York on this untried warrant. I'm sentenced to 5 years. Under the act, they're required to return me to Vermont as the primary jurisdiction. And at the end of my 2 years, I have waived my right to extradition based on this transfer process. And New York now needs to come pick me up to finish my term of imprisonment in the other state. But all of that starts with an untried warrant that has been lodged as a detainer. Again, then there's the pre-signed waiver that's associated with that transfer. That's under Article 3, which is the inmate's request for disposition. On the opposite side of that, there's a prosecutor's request, which follows the same process where the documents are provided to the state of Vermont. They certify who the person is, photographs, fingerprints, what we've outlined in this bill, and that they intend to seek custody of this person. Under that case, it follows a similar process to the governor's warrant because the individual is not willing to waive. And they wait a period of time for the governor to step in, and then ultimately could have a habeas filed, but they are sent to the other state, the demanding state, for resolution of those charges. It is different than.
I'm sorry. So I just want to clarify what I understood you say. So the individual could be getting held past their sentence in Vermont based on this detainer up until, the time that they are transferred to the other state. So there may be the equivalency that are being held without having gone through a court process. That's what I'm trying to get at as well. And I understand the other point is that DOC is competent in reviewing these kind of documents to figure this out. But I just really want to nail that
Yes,
down.
there is a period of time in which an individual could be detained in the state of Vermont based on this pre-signed waiver associated with the transfer before they're returned to the other state.
Okay, thank you.
Yes.
That's that's very helpful. The further explanation was very helpful, but I think that's the main thing I needed to understand. Is that equivalent with the compact for supervision of adult offenders?
So the interstate compact, which is the term that's interchangeably used. So ICOTS is what you would typically hear it referred to in DOC language, is the supervision of people under either parole or probation. If they violate that supervision in this state, the corrective procedure is for the Department of Corrections to take them into custody based on the warrant issued in the other state, hold a probable cause hearing if requested by the other state, and then detain the individual up to 30 days for retaking. Because under the interstate compact, any person who is party to any state that's party to that compact waives all legal requirements under their specific state statute for extradition. And you're to follow the federal, and both of them are federal acts that oversee the supervision and transfer of custody.
I appreciate that. So other questions for Morgan? I think that helped me in my simple mind trying to figure this out. So I'm sure that when the Defender General comes and actually reviews this, I'll ask them right now when they come in. I want to understand why they think that those two processes are not equivalent and not something we should base our comfort on the S87 amendment based on the fact that it seems to be occurring in these other situations. So that wasn't a question for you. That was a question for whoever's going to be testifying next week from the Defender General's office. I really appreciate your time. Thank you for being available on short notice. This has been very helpful. And we'll go to Kim next.
Question?
Yeah, so do you have another question?
No, thank you very much, Morgan. Really appreciate it. Should we wait until we have a quorum again?
No, we started with the quorum, and so we can at least get through this. Maybe we'll wait for the next thing that's at 10:30. But yeah, we can have our last witness. That's fine. My understanding is you have to start with it. Well,
My understanding
my understanding is
you don't need a quorum at all. I just want to hear you say it out
it's
loud.
it's a practice. It's a practice here that we do want a quorum to start. So I'm following the practice, though not necessarily Masons or others. Having said that, Kim, come talk to us about something much simpler than whether you need a quorum or.
But if you want to opine on that too.
I know.
Yeah, you're welcome to opine on
I was
that.
just trying to look it up because I wasn't sure. Good morning, Kim.
There's nothing against you that people are, I have a feeling that it's because of what's hitting the floor this afternoon, that there's probably a meeting going on with some of our other members, so.
Meditated this morning. I'm not taking it personally.
Okay.
So I'm okay. So I don't think I got through it all with Kim McManus from the Department of State's Attorneys and Sheriffs. I'm going to just make a few comments, but I'm also happy, of course, to come back next week when when the Defender General's office has a chance to weigh in, and then any further comment. A few things just to highlight. While there are differences across all the states, to some extent, the Uniform Extradition Act does require that before someone signs away these important rights, the waiver to an extradition process, that a judge runs through and explains to them, here are your rights, and you're agreeing to waive them. And it's the process that our judges do during our extradition process when somebody signs a waiver in front of them. So that process that happens here is what has happened in other states, when somebody has signed this waiver. So to the chair's point, a person may argue if they didn't understand the waiver for some reason, right? And that is definitely where I believe the Defender General would come in. And when you, on that point, and when you look at the cases across the country, it is that check of, was the waiver process done properly? So we are to some extent saying here, we're going to trust the other state that did this, similar to we're going to trust Massachusetts providing a license to their drivers, whether we like how Massachusetts drivers drive or not, right? We acknowledge that license here. That's that, I always get the wrong word,
Comedy.
the comedy, thank you.
A comedy, but.
Exactly, I'm like, oh, I'm gonna say it wrong.
COMM.
COMIT.
Okay.
The states honor, right, that these various processes in the other state. So I do want to be careful that this isn't taking away that part of the due process of understanding that they have signed a waiver. That is why it's this very separate subset of individuals that we're talking about here, that we would create this off-ramp from our process. And what the language we presented here was to make sure that the operation of that, of what the law enforcement officer would need to do at the onset to bring this person to the Department of Corrections, that they're going through and making that first initial check, right, of making sure everything is in order before they bring someone there. And again, very important that it has to be an extraditable warrant. That officer does make that phone call. They need to, that's part of the paperwork. Yes, this person has an extraditable warrant. The state wants them.
Yeah.
They've confirmed that, right? They have that all pulled together and then go to the Department of Corrections. And this statute, this language would just be confirming that our Department of Corrections has this ability to hold. We did think it was very important to put guardrails in, and that's the timing that needs to happen. And one thing that Morgan did not mention, but I thought was very compelling when I had a meeting with her last week, was our Department of Corrections does not want to keep anyone here longer, any longer than, so the 14 days is a backstop, right? To make sure and to be able to express that to other states. Like, look, after 14 days, we have to start our process and this person will go in front of a judge. And then unless it's a life offense, will more than likely be released on bail of some amount and may be held on that bail, right? But there's a question mark demanding state. And here's where that question mark comes into play. So you have 14 days. And DOCs is not dragging their feet on that 14 days. They don't want to hold this person. They want them to go back to their other state.
Ian, and then Barbara.
Yeah.
Barbara, then Ian.
No,
Okay.
no.
Sorry.
Roller coaster. So just a quick language question for the 14 days in line 20. So if the person is not delivered to the demanding state within 14 days, so we heard some testimony, and I do not recall from who, about like an individual having to take a very circuitous route back to the state in which the warrant is. The way I would read this is that that individual needs to be back in the state within 14 days. And so I wonder, does that mean that if you've got a state that's a lot farther away, they need to be accounting for that transport time as part of the 14 days to be compliant, for Vermont actually to be compliant with this?
I was looking to see if Morgan is still there. My understanding, and I can double check on this before we come back on this, is that that term delivered to the demanding state, it's part of the language of the Uniform Extradition Act, which again is from, I think, the 20s or 30s. And that delivered to is when our state hands off this person to the demanding state. So how the demanding state decides how that person gets back and the time that takes, that's not something we're responsible for. So our delivering is, sort of opening our door and being like, here you go.
Yeah, no, and I remember that kind of being explained, but I couldn't remember exactly what the distinction was. Okay, so maybe that it's just about, okay, so maybe that's not an
It's
issue.
when the demanding state has, had the person or the entity that has come to us to take this person and take responsibility for them.
Yeah.
And then, we cannot dictate to another state, whether that person is on Greyhound to California or taking a flight.
Yeah.
That part we can't control.
Okay.
Yeah, go ahead.
So I was gonna say, you gave me a lot to think about, but I don't think my questions are for you. I think they are more for the chair and for GSC. So, thank you. I mean, it's insightful, but I wrote them down for later.
Okay. Any other questions, or did you have more that you wanted to cover? Yeah, Angela.
I think I know I'll admit, I think I know the answer to this question, but I want to just hear from you for sure. I have in my notes that you brought up this issue of needing a connection with the courts to ensure the lawful hold. And so does this, I'm guessing you worked on the amendment and that it satisfies you as
Yes.
a department.
Yes, so my issue when we were reviewing the original, the language without this amendment, and Representative Oliver had brought up, on the ground operationally, like, law enforcement officer, how are they walking from, their car that they've just held this person and walking up to DOC? Like, what do they have to say you can hold them? And that's where I had gotten stuck. That, usually we have a judge's order that is holding someone, for the night till they go in front of the judge. And so my panic is a strong word, but my little like, oh, wait a minute, was what can DOC, what do they need to be able to hold this person? What process do we have? And so, yes, I had raised whether or not we needed that judge's order for Department of Corrections to hold them. And in our conversations with Department of Corrections, they said no. And that, again, they gave all these other instances where they're able to hold someone. And again, as long as the statute makes it clear that they can and under what circumstances. And so with that, and with laying out, this is what law enforcement would need to do at the onset.
Yeah.
Before presenting this person in this way, I believe that takes care of the concerns that I initially had.
Thanks for that question, too. All right, good. So we'll continue this next week when we hear from Defender General and hear from you and Todd again and Morgan if necessary to answer questions. So we'll be fully informed for whatever decision we need to make.